Hey, welcome back, folks. This is Joint Justice Oversight Committee. It is July 2nd. We are continuing our meeting this afternoon, and we're going to be starting with Judge Stoney to give us some updates on the court systems. I know that there's, yes, way down there. I know that there's initiatives that were put together during this past legislative session, so I can lean on Representative Martin Lalonde for some of that, because it did come out of judiciary committees as well as Senator Norris. So I'm going to turn it over to you, Judge, and it's all yours. Welcome.
Okay, so good afternoon, everyone, those present and those who are appearing via Zoom today. For the record, Tom Zone, Chief Superior Judge. I thought I would just speak with you for a few minutes about some of the initiatives that have been going on. And during the legislative session, the legislature enacts the bill with the governor, and then it comes to the court, and we often wonder what's happening after that. So I thought it would be helpful to just let you know that with respect to the legislation that's been enacted, there were some that became effective upon passage earlier in the session. And other statutes were yesterday. July 1st is that magic day for most. After the court is notified, after the judiciary is notified that a bill has been passed, what we do is we come up with summaries. And we have a summary that is provided not only to internally, the staffing side, but also the judges. We also had Judicial College in early June, and as far as the bills that were enacted as of June, on or before June 13th, because I did a training on this on the 14th, but on the 13th, we told the judges what the new bills were and gave them summaries and went over the different bills that were going on. Of significance, there are some bills that had some changes on July 1st, and I would note H27, which was the coercive and control bill that added coercion and control as a basis for getting a relief from abuse petition. And so that started yesterday. There have been trainings done not only to put the judges on notice of this new law, but also for staff, to have staff understand the new law. And training has been done with the after hours workers. In addition, the forms were changed. And so the forms were put together, and we had them effective as of July 1st. And so we are moving ahead with that aspect of the H27. And we also did, I would note, a training at Judicial College with judges that touched on coercion and control. So it's something that we have in response to the legislature moving forward on that addressed. In addition, it's not just the H27 changes for forms, but any other form changes that may have been necessitated have also been implemented. We're also, the legislature and the governor agreed that we should have some new judges and staff positions. The governor's office has sent over the request to the Judicial Nominating Board for the vacancies to be posted so that we can move forward with that. We got some work out of that, Senator Norris. And also the judiciary is moving forward to try to advertise and fill the other positions. When we talk about positions, staffing is something that can always be challenging. Not only when we get new positions, is that helpful, but it also fills positions where people are retiring. So we've lost two of our court clerks to retirement, longstanding ones. And so up in your neck of the woods, Senator, Gay Paquette, she retired, and Chris Brock in Chittenden retired. And so steps are being taken to fill those very important positions. The judiciary used to have and is now reinstating what's called a day in Montpelier for new employees. And what that means is when someone comes in, we want them to realize you're not just a judicial assistant or staff member in X court in X county, but you're part of a very important organization, separate branch of government, the judiciary. And we want people to understand the importance of that. So the idea was to have staff members come in to the Supreme Court early on and get to see what's going on there, to recognize that, again, we're all in this together. It also establishes relationships between employees who might not have met if one's from the north part and one's from the south. So it's something that we understand has been effective. And Terry Corsones, the court administrator, and Lori Canty, the director of trial court operations, have been wanting to move forward with that, to re-implement that. We also have been, with the way our staff was structured, we had a number of limited service positions that ended on June 30th, this weekend. And so what has happened is, for instance, we had operations assistants who would work on WebEx. So when there was a WebEx hearing, what the individuals would do is their role was to serve as the producer, if you will. Make sure it comes up on the screen, make sure people are let in, things like that. With those positions being gone, what we now have done is the judicial assistants have been trained on how to support WebEx. And so that's a role that judicial assistants are undertaking. Good news comes, though, in the form of the fact that the individuals who were the operations assistants, all but one, have transitioned into full-time employment with the judiciary, not limited service positions. So we have been able to take the knowledge which they have gained over the years and keep that in the judiciary as they move forward. We also have, you may have heard something about technology in the judiciary, The network migration has taken place. It was successful, moving ahead. Are there times where you go, wait a minute, I don't understand this? Yes, and we have our tech people who work with us to make sure that things are moving smoothly in the right direction. There has been a upgrade to what was once called Odyssey. The name now is Justice Enterprise. They changed the name, I believe. And so we have also had an upgrade to that. And we're moving ahead with technological changes to make sure that we get it all done right. Included within that is the implementation of a digital evidence management system. What that simply means is that when you had, in the old days, if you had an exhibit that you wanted to introduce, you'd walk into court, you'd have a binder with it, you'd hand it, and you'd say, here's exhibit A, can you look at this? Now there are requirements to file things electronically ahead of the hearings in accordance with specific standing orders. And if someone can't do that, there's also the flexibility to allow them to do it differently. If there's something not working, or someone doesn't have the technological ability to do that as a self-represented litigant, for instance, we work with them to make sure that justice does allow them to have the exhibits admitted. But we do have the procedures down where there is a requirement that you do file it ahead of time, except for certain limited areas where there may be exceptions. We've also successfully migrated all arrest warrants to a digital platform. What it used to be was arrest warrants would be sent to the county, to a holding station for each county. And if an officer wanted to find out whether there was an active arrest warrant, he or she would have to contact that holding station and basically to see what's going on. And my understanding is that in some of the stations, it was literally files, pieces of paper and files. And that's now changed. We now have the Vermont Order and Warrant System, which is digital, statewide, and I am advised that all law enforcement have access to it. That is also taking place with regard to county protection orders for each county. That would include relief from abuse, stalking, and extreme risk protection orders, which were also paper in certain areas. And that migration is ongoing and is expected to be completed by September, in which case we'll have all the orders accessible by law enforcement, and that will certainly be something that is much easier to do than calling and asking to have something faxed to you or emailed to you. Buildings. Yeah.
Just a quick question, Judge. Going back to the restraining orders, what about the after hours restraining orders as far as that? But no, who's entering that? Just curious.
Answer it?
No, if someone is issued or given an after hours temporary restraining order, how does it show up in the database?
It will show up under our system once it's been issued and entered. That's my understanding.
So the person who's entering it is going to enter it themselves? The person issuing the
There is a process by which orders are put into vows. And so the after hours staff would make sure that things are taken care of with the clerks to do that.
Good. Thank you.
As far as buildings go, well, Windsor County. Well, you're actually right in the middle too, Windsor and Windham. We have two construction projects going on. The project in Windham County is going to be, I understand that a roof windows, things like that. The plan is to continue to have court operate in the state building on Putney Road while the construction is ongoing. Will there be times we have to maybe scale back a little bit or have disruptions? Sure, we understand that's going to happen, but we're going to be able to stay in that building and continue to work and try to facilitate and maximize our ability to use that building while it's going on. The Windsor project that's happening is a little bit different. For those of you who know, in White River Junction, there is a courthouse downtown. And that is that is the family and criminal divisions. That building is going to be shut down. It's not been finalized as far as a date. That building also has within it the Judicial Bureau for the traffic tickets and fish and wildlife, minor and some municipal complaints. Right across the street is a building that just happened next to the railroad, is a building that's one of the newer buildings in town that had an opening and there was a vacancy. And so the Judicial Bureau and some staff from the probate court in Woodstock are going to be moving into that building. And then we're going to have the Woodstock building, which is the civil building. That's going to be used basically as the in-person trial building. We have hearings on the second floor. You can have trials there with jurors. On the first floor, there is the probate courtroom, which can also be used for non-jury work. We are looking at attempting to utilize the county building, which is what we did last time. There was a construction project on the civil building. The county building is the one in Woodstock that is the old jail. And so there's space there that we can also utilize for staff and for hearings if possible. We also right now are waiting on in the civil building. When they built that and redid it, they did not put a holding cell in. And so we're working on having it retrofit with a holding cell to be able to do incarcerated individuals there. So there's a lot of moving parts. It's going to take quite a bit of scheduling. We're going to have certain hearings are going to be remote hearings going forward, but there are ones that obviously cannot be remote. And so those are the ones that we're going to make sure are taking place in the Windsor Civil Building there in Woodstock.
So Judge, I have a question about the holding cell. Is that request coming from the judiciary for the holding cell?
Yes.
And is that a last minute thing that kind of came up, or has that always been in the plans?
When we were notified that when we came up with the idea that we're going to have to move and we were looking at different locations, one of the things that we talked about was the necessity of a holding cell. When we were looking at the potential for using the civil building, we reached out, and I actually personally reached out and spoke to former Assistant Judge Jack Anderson, who was the one who had done the building. He explained that when they did the building, they did not put the holding cell in a certain location, but he did tell me that we did actually put in plywood behind the walls and did the door frame so that there was a room that was in some ways able to be used, so you didn't have to recreate the wheel. And so we have always talked about that as being a requirement because we would not be able to have criminal cases there with individuals in custody without it. The Sheriff Palmer has been very helpful as far as working with us to try to come up with solutions, not just for that type of issue in the building, but what happens when we have several individuals at once who are going to be there. And the sheriff is working with us to try to make sure that we're able to deal with that.
So when will that holding cell be up and operational, do you think? Because ETS would be involved in that.
It is correct. We had a meeting last week and at that time, they still do not have the permit, I believe, and we don't know the date because that's what's holding us up to know about when we can start there.
Right, because there's been some confusion back home in terms of where arraignments are going to happen, and it was scheduled up in the Woodstock court at certain times. Now it's moved back down to the White River.
At one point, there was talk about having things moving out on the beginning of June. I'll tell you, my position was that we should not be moving until the absolute last moment because the disruption from White River is going to not allow us to be operating at 100% in terms of what we can accomplish in the building we have now in White River. And so Ann Damone, who is the clerk for both Wyndham and Windsor, she's got two construction projects she's dealing with. I know that Ann has been working on that very topic, and the question came up just last week about where are people going to be cited, because we're citing out 6 weeks.
Right.
For hearings. And so I know she's been in touch with law enforcement, and we have other meetings coming up, should be next week, with BGS to try to get more specific dates. What is the date that we're going to have the holding cell when we can actually start using things there?
Okay. Thank you.
So we also had, you may have heard over the past couple of years of the session, there was something called a backlog. And
Now they're all incarcerated.
I thought it might be helpful to just give some idea on, we have a clearance rate. The clearance rate is how many cases are coming in, how many cases are going out. And with respect to a clearance rate, when you have a backlog, you're never going to get rid of your backlog if you don't rate above 100. And so we have goals for what we're trying to accomplish. And I thought it would be helpful if I gave you the 13-month average clearance rate. I can give specific counties too, if you'd like. But for criminal in the state, our clearance rate has been 110%. For civil, it's 119%. Family domestic, 102. Family juvenile, 119. Probate, 114. Environmental, 129. And judicial bureau, 104%. And so for the past year, or 13 months, we have been making inroads and reducing the backlog. We have some counties that, for instance, in the criminal clearance rates, our highest county this past, as of June 28th, we had, was 136%, we had 124%, and it varies. Some months you get a really high number, some months it's a low number. There's a lot of different reasons for that. But in terms of the rates, we are happy to say that we're over 100%. And the plan is when we have the new judges, we're going to continue to get those numbers higher. We have taken strategies that we think have benefited us. We've tried to maximize the use of remote hearings. The stresses that are on the system, I know heard from DOC today, there's significant issues that we face. DOC faces issues with respect to staffing and the ability to monitor and be there to run, if you will, the remote hearings from the jail. But we also, on the other hand, have the Department of State's Attorneys and Sheriffs. The sheriffs don't have enough individuals to do transports. And so DOC has its policy on when it's going to allow remote hearings. The sheriffs have their policies, and the two aren't matching up quite as well as we would like. And so we have an inability to bring everyone to court due to transports, and an inability to do all the hearings remotely due to certain constitutional or rule limitations, but also the fact that the Department of Corrections is saying, well, we don't have the staff to be able to allow you to do all these other hearings remotely. And so they have put out a standard operating procedure that says these are the limited hearings that you can do that will facilitate remotely. And it wouldn't include a number of civil and other matters. And so we're working on trying to address that. They have been, I would say, to the Department of Corrections, they have been very responsive when we've had concerns. The commissioner and others in the department will talk to us about it. They're under difficult circumstances. And so I think that we just had a circumstance last week where I know that the department worked hard to make something happen that might not have necessarily happened otherwise. And so we really appreciate the efforts they're making, but we're all, the Department of State's Attorneys and Sheriffs, the DOC and the court, we all are trying to get the same goal, but it's difficult when we're having trouble getting people to court.
Are you finding, or is there for DOC and the situations of trying to get someone to do it electronically, is there a facility or a couple facilities that's more problematic than in others that you're finding, or is it pretty even across the board?
I think everyone's working hard. For instance, Terry Corsons and I went at the meeting we had down at Southern States, and Vice Chair, I was listening this morning, Vice Chair Emmons was at that meeting. And Terry and I had an opportunity to go out and see the facility, to visit with the men and women who were actually working there at the remote hearings. And they were great. They're working hard, they were engaged, they were interested, but they've got a lot of things on their plate. And so when we have difficulties, I think the difficulties are really more a function of just the practical aspects of trying to get more staff and having staff do a number of things. DOC has roles of programming, roles of reintegration they have to be working on. So they can't just be there working on the remote hearings for us all day. The attorneys from the Defender General side of the equation, they're stretched. We have Matt Valerio, the Defender General, has done a great job of getting attorneys to be able to take cases. And some of those attorneys are in different counties. And so their ability to work remotely and interact with their clients is important. And so it is a lot of these different parts moving. And frankly, it's impressive to see everyone working hard. And it can get frustrating because we're not all getting what we think we need to be, where we need to be. But that's, it's just a function of where we are, and we have to figure out how do we make things work as best as possible under the current circumstances that we have. It's our hope that when additional positions are going forward with DOC, when the sheriffs start getting more individuals hired, that the security, transports, DOC, that we're all able to get working at a level that's higher than where we are now. Any questions you have?
Well, I've got a question. This morning, we went through some items with DOC's an update. And one thing that has really stood out was the number of detainees that they're seeing. The number has now risen to about 540, 550. We've never been that high. We've been more around 350. We've been bumping up to 420, 425, 450. But when you're reaching detainee population at around 550, and we have a little bit like 900 folks incarcerated, that's more than half of our incarcerated population are detainees. So when we ask DOC what's happening here, what are they seeing? They're saying, well, we're picking up from the court backlog from COVID. I just want to get your take on this. Is it that we're catching up on the backlog from that? Is it that there's more awareness about the public perception or public concern about public safety? People are arrested and then released, so now they're being held. Is it a reaction to the public concern? Is it that folks are coming in, they have a higher risk of flight? They're being held without bail, or they can't make bail? I mean, what's 550 is pretty high.
As of this morning, there were 440 state detainees. And then there were 80 federal. So that gets us into that higher number. So the 440 is the state number.
Right.
When I look back to this time in June of 2023, that number was 394.
For state?
For state. This is state only. In June of let's go to July, actually, because we're July 1st. That's my date. July 1st of 2023, it was 421. 2022, that same number was 368. 2021, 315. 2020, it was 304. And if you look in the different months during those prior years, we were down into the 200s. During the pandemic, it dropped down. And then it went back up again. I think it's difficult to say that the reason it's going up or down is attributable to one factor. There's any number of factors. Those factors include the backlog. That is certainly something that is a factor of pretrial detainees. If we're not having the cases go to trial or the cases resolved, then we're going to have those older cases sitting there waiting for trial. And as new cases come in, it's going to increase that number. And so it's important to keep in mind that one of the most important ways we have to deal with the detainee population is to keep scheduling trials and holding trials. We're not going to try our way out of it. Statistically, if we said we're going to have a trial for every case, the system would not be able to do that. Over 99% of all cases settle or are dismissed. So it's the vast majority of cases are resolved short of trial. And so I can't put my finger on it and say this is the reason. Each of the factors that you talked about could certainly be playing a part, and how much each weighs on the scale of each particular case, it's something you really can't tell. I do note that the 60-day cases, where when someone has a 60-day case that they're held without bail, our goal is to get those cases heard within 60 days. So they go right to the front of the line. And that sometimes creates a little bit of the backlog too.
So another question, and this is coming from the work that my committee has done on home detention. And now we have 6 people on home detention. It went up by 2 from what was there back in April. But our judges, because we've expanded the conditions of release through our pretrial, say supervision program, because that hasn't really gotten started, but through the bill in general, we're trying to get more folks to be supervised in the community, be it either electronic monitoring or home detention. And what's been the process up to date today to work with judges so that they be more amendable for home detention, possibly the electronic monitoring piece? Where are we on this?
I have visited with the judges, as I've said in your committee during the session, many times about the home detention numbers. We've talked about the fact that I think it was very clear in the 2023 session that I think the phrase was use it or lose it. That if judges think it's important as an ability to have home detention, why do we only have so few cases? And why are the numbers going down? So judges are aware that that is a potential. I think it really is a function of judges looking at the particular cases that come before them. And when I talk to the judges about why are the numbers staying where they are, one of the things that keeps coming back is that when you order that report and you're coming for a hearing, the fact that someone does not get put on on home detention doesn't necessarily mean that it wasn't effective, because many of those cases will resolve with a plea agreement or the parties come up with conditions of release. And so if DOC, let's say, is asked to do 30 reports, whatever the number was, I think last year when I checked this, there was a time when DOC was asked to do a certain number of reports. And I think the natural tendency would be to think, well, DOC did 30 reports and we only have 6 people. But when we looked into it closer, what we found was that the majority of those people who had put the reports in, their cases resolved, or they were released on conditions by agreement. And so they didn't need to go to home detention. And so if the test for whether home detention is effective is simply going to be the number of people on it, I would suggest we're not capturing the entire benefit of it, because it is something that when that is a potential mechanism for release, it doesn't bring the parties together. Because what we know is oftentimes when the state and the defense get together, they have the ability to resolve the matters.
Questions? Yeah.
I got one. For several years now, I've been concerned about people being released who might have been incarcerated. They go to the hearing and then they're released. And they have certain prescription drugs that they need to take, but there's no provision for them to get them when they're released by the judge. Can anything at all be done about that? Or even hooked up with treatment programs as well? if it was a drug related.
The court does have the ability to order that someone and get engaged in an assessment and services that they may need. Question on that person connecting is really outside the ability of the court. The court can't say, well, we want you to go to this program and we're going to make the arrangements for you. We can identify the program and we can try to help. But that's where the attorneys may come in. That's where community resources come in. The bill that went forward that has the pretrial monitor.
Yeah.
I'm sorry, the pretrial services,
Yeah.
Monitor that went through. If that goes through, that's going to provide, because one of the key components of that, it wasn't just watching over someone, but it was assisting them in getting services and assistance that they may need. That's a mechanism that can assist individuals with doing that. As far as individuals who need, who may have prescription needs, I think it's fair to say that when a judge is made aware of someone's particular needs, he or she will go out of their way to try to say, okay, what can we do to help? Recognizing that our role is limited, but if I can make a decision or if I can facilitate someone making that call to do something, whether it's contacting DOC from the bench and saying, can you contact DOC and find out what's going to happen with the transition of the medication, their meds who are in jail, how are they going to get this, what's going to happen? Or just asking the individual, you take medication, what's your plan when you leave? Do you have it set up? Where are you going to get it? And if they say, I have no plan, looking at the prosecutor and defense attorney and saying, okay, what are we going to do? Looking at DOC's representative and saying, how can we address this? Because we're in the people business. We're trying to help this individual get medical attention and correctional attention and treatment they need so that when they go out, they have the skills to succeed.
That sounds good. In theory, in practices that's going on.
My understanding is that that is the practice that many judges implement. And I can tell you that the fact that you asked that question, there will be more judges, as in all the judges will be aware that this is something we really need to focus on. I meet monthly with the judges, and it's questions like that are, I would like to say to you, I have specifically talked to the judges about this question, and here is what happened. And I can't say that today, but the next time we speak, after we have our meeting, I'll be able to say that.
Good. Thank you.
He's gonna hold you to it too. You're gonna hold him to it.
Absolutely.
Other questions?
That's a big deal.
Martin came on board here. Do you have anything?
Yeah, I have a couple questions as well. Nice to see you, Judge Zone.
Good to see you.
So it's more about getting a couple things. First of all, the stats that you just mentioned as far as the clearance rate, if you could provide those to our committee assistants so that we can put them on the committee's website. And I know that the court and you and Terry are very good at providing those statistics upon request. But I wonder if we could plan just generally that those are provided to this committee for each of its scheduled meetings. And this is something I know we're going to be talking about a little bit later as far as what this committee should be doing for the rest of the off session. Yeah, I will preview that I believe we should have somebody from the courts in for at least an update each time and look at where the stats are and look at how the staffing is being filled. So I would request though that it also include just the time to disposition stats that we've relied on in House Judiciary Committee. So we can follow just the trend. I know that it's going to take a little while to get everybody on board, but I think we should just be on top of that. The other thing it has to do again with stats is, so that was a request, not so much a question, is with respect to the detainees, which I guess this will also be more of a data request. I've seen the raw numbers and high level numbers for detainees over the past couple years. But I think it would be much more helpful for us to understand where what's driving this and how big of a concern it should be, if it's broken down. I know that I've seen the stats where every individual detainee is listed, and that's actually somewhat helpful, but it would be good to have some summaries as well. But I think it's important for us to understand who's held on bail, who is held without bail, those who are held on bail, what the bail amount is. I know I've seen those reports already, but a couple things that I guess they also has the underlying charges usually in this report that we've seen.
That is a report that DOC generates. If
Yeah,
I want to
yeah.
copy that, I get that from DOC and it has all the information you just indicated, correct?
Okay, so there's one further item. So I guess we can go to DOC for that to make sure we get that. It would be nice if they would do some of the summaries, such as summarizing how many are held on bail, without bail, et cetera. Anyway, but they also, I don't recall that report has the duration of detention of each of those individuals plus the average, because I'm curious how much of this is somebody who's being held past 60 days, or is this constant churn? And we happen to have a lot more people who are being held without bail or are committing crimes that they can be held on bail. They're only held for 30 days, but there's a lot of throughput. And I don't think one can gather that from that report very easily. And I think that would be very helpful. My concern is more so those individuals being held for a long time, being detained, as opposed to that raw number is of less concern to me. It's why they're being detained and for the duration. So I think that would be helpful.
I do have actually my notes that I read from. I prepared a PowerPoint for myself to go with notes. So if that's okay, and it had that last slide I went over with the clearance rates on it. If you'd like, I can send that to Ms. Cannella.
Yeah, that was,
Okay.
so I just want clarity in terms of looking at the detainees and seeing, I have seen that list of underlying charges, how many are held with bail. That's all generated by DOC.
Yes.
And even the length of time in terms of how long they've been detained, that's also by DOC.
I believe DOC has that information. Yes.
So that we know where to go.
And if DOC does not have it, I will look on our end to see about what we generate, but I'm pretty sure that's where I have seen that information from, is the DOC side, because I know I see that information.
I've seen it too, a variety of times. And it is very enlightening to look at this. Because we may come at it with certain assumptions, and then when you look at it, it throws those assumptions out the window pretty quickly. Anything else, Martin?
Yeah, I mean, the other thing, and this is probably more of the later discussion, I think we need to have some further look at really where the issues are with remote hearings, how that's working. But I would also add to that, just to get it on Judge Zone's list there, is that I've heard from numerous individuals that the fact that in some respects there can be too many remote hearings, and there's a great benefit, particularly I think, in having the defense counsel and prosecutors at the courthouse, because a lot of business can be done more expeditiously. I don't know how that works with not having the defendant there, but I think that's one aspect that should be looked into, and whether in fact there should be some more requirements that prosecutors and defense counsel actually are there in person so that business can get done more expeditiously.
That is very true, that statistically it benefits us when we have the parties there, because you can sometimes accomplish something in person, even remotely. The difficulty that we run into is that the pressures, if you have an attorney, for instance, who has a contract and they're in Burlington, and they agree to take a contract in one of the southern counties, to get them to come down for a status conference to Windsor County is very difficult sometimes, because they're not able to then address the Burlington cases that day. And so this is where I'll say it's more of an art than a science for the judges to be able to figure out, okay, do I need the person there, the attorney there and the client there? Is this one of those moments where they have to be there? And relying on the prosecutor and the defense attorney, there are attorneys who will say, look, Judge, we should be in person. I think that'll give us a chance to resolve things. So the attorneys will self-select on that also. But the difficulty we run into is if we're having attorneys and saying, we need you in this county in person, we need you in that county in person, in this county in person, and the attorneys are viewing it as just a quick status conference. I think you could hear from Mr. Valerio. I suspect he would tell you that you have attorneys who would tell him, we shouldn't have to drive there in person for some of these hearings. And if the choice is take this contract and drive all over the state, I might not take the contract. And so I'm aware some contracts might not have been renewed coming up. And that type of overload is one of the factors that I have been notified of. And so it's a real balance, trying to figure out how do we maximize in person and yet respect the idea that we can possibly also have a gain by having remote for some of these attorneys to be able to operate in multiple counties as they are doing.
And I guess I certainly defer to the court as a separate branch and trust the judgment of the judges in doing that. But it would be helpful if we had some sort of statistics on that as well. And I know that in last November's joint rules, the Judicial Rules Committee, which I have the pleasure of serving on as well, that there was a request when we were looking at rules for when a judge can decide that a hearing is remote or joint, or both remote and in person, that they were going to start getting us some idea of how that's working and how many hearings are being held as remote, as in person, and as both together, which I can't remember what that's called.
Hybrid.
Hybrid. That was a very difficult word that I was having trouble.
That's what we're having today, hybrid.
Yeah, exactly. I think it's my father's aphasia is catching here in Virginia. In any event, putting that aside, I don't know if Emily Weatherall was the person who was there, and if there's just some follow-up to see if there is some sort of data that we can see how that's working, just so we can keep tabs. I appreciate your time. Thanks.
Thank you.
Great, thank you, Martin. Any other questions?
Yeah, a little bit of a question. It's something I was going to bring up later on when we were talking about getting updates. But Judge, thank you for being here. And I know you're working really hard with the Judiciary Commission on Mental Health in the courts, and Martin and I have been involved in that. Are there updates that you can give us suggesting that the work that we're doing related to mental health is improving wait times or other aspects of court process? I mean, at some point, get a full report.
The changes that were implemented last year with having the ability to use doctoral level psychologists, changes that were made at that time have definitely shortened the times. And I believe Department of Mental Health would be able to have information about that as far as specific times from when they get to report the request for the competency evaluations until the time they get that. So those times have shortened significantly, I believe. As far as the other changes, there have been a number of changes that were done this year also, and I think we'll still have to wait and see. There were changes that talk about whether individuals can testify remotely for the examining physician. There was changes to make clear the burden and that someone is presumed competent and the burden is on them to establish incompetence by preponderance of the evidence. Those were the types of changes that I think over time we'll see how that move forward. The changes this year with respect to individuals with intellectual disabilities will be significant because, as I testified during the legislative session, it was helpful to have a rewrite of those statutes to address the procedures so that everyone's on the same page. There was a lack of clarity and procedures that were not able to be clearly followed. And so this is something that we think is going to be beneficial to have it going in a predictable manner in terms of what is the law.
Thank you.
Can I just have a follow-up to that as well? So Senator Lyons and Representative Wood and I have had the opportunity to sit down with the federal court folks in Burlington. Judge Rice has really been pushing this, but it was also the defender, the U.S. prosecutor. There were a number of individuals from the administration and Dr. Levine. The one missing, I didn't notice that there was anybody from our state court system. And it seems like, and this was a meeting talking about really the duration of addiction, substance abuse or substance use recovery. And really, they're really trying to push on and looking at ways, and Senator Lyons knows the details of much more. I was a little bit out of my jurisdiction there, or maybe not that, but certainly out of my knowledge base. But I think that was an important effort that they're really pushing, that hopefully our state courts can coordinate and be part of that. That might help this along. If hopefully Senator Lyons can weigh in on this a little bit further.
Well, and really it relates to our recovery centers and the bill that we passed relating to recovery centers and getting some systemic improvements there, some connections between the courts and between referral, medical referral and recovery centers. So we're at the beginning stages, I would say, of this work, but it was a really good meeting. And it would be helpful to have the courts involved in that. More involved, our state courts, because we were really talking at the federal level.
So my understanding is that Judge Novotny, who is going to be the backup treatment court judge up in Chittenden County, has now had an opportunity to reach out with the individuals, Judge Rice and others from that
Good
group. And as you know, I know Representative Lalonde knows this very well, because he was pushing us to more judges, and we agreed. We think it's very beneficial, but one of our plans is to have the statewide treatment court judge who's going to oversee all the treatment courts. And Judge Griffin was put into that position. And so I was in touch with Judge Novotny last week, and the plan would be to have Judge Griffin circle back with Judge Rice and others in that group, because we think it would be beneficial for him and or Judge Novotny to be involved. So I do agree that it's important for us to have a seat at that table.
Any other questions?
Thank you, Martin, for reminding me and us of that. It was good.
Other questions, thoughts? Thank you, Judge.
Thank you very much. Have a great day and a wonderful summer, everyone.
you take that.
Oh, thank you.
Right back up to Maine.
I will do that. Thank you.
I hope you get to stay up there for a while.
Till Sunday, and then
You're back home.
we'll be back. Thank you. Have a great day, everyone.
See you later.
Yes.
Take care.
Thank you. Okay. So now we're going to shift gears a little bit. We're going to put on our Justice Reinvestment 2 hat. We have Amy Pope from Joint Fiscal Office. And I think we do have a handout as well. This big handout, I'm assuming. Just trying to understand how much money over the last couple of years has gone into justice reinvestment, and where it has gone. And that just sort of lays the foundation for us to start understanding justice reinvestment. And then when we get all the reports that we're supposed to be getting with all this data in the fall, then maybe we can collate, connect all the dots and see if where we're putting the money in is getting the results that we want. If it's not getting the result that we want, what do we need to do to change? Either the money goes somewhere else, or we need to approach it a little differently. So, Amy, welcome, and if you could identify yourself for the record.
Yes, Amy Pope with the Joint Fiscal Office, and let's see if I can share my screen. Oops, I just logged out, sorry. There is a link on your committee page that has this, while I get back in here. So what I did is, you'll see sort of two sections. One says the AGO court diversion, which I'm not sure if you want to go over, or if you want to focus primarily on, the DOC sort of traditional, Justice Reinvestment 2 is the appropriation title.
I would do the the Department of Corrections one. Because the court diversion and community justice centers, in terms of that piece, is, to me, it's separate from the justice reinvestment, the purity of it, in terms of you have bed savings, you invest those savings from the beds into community programs.
So I thought that is what you wanted.
Yeah.
So what I did is I sort of tried to focus just on I took the spreadsheet and I just focused, primarily on DOC. So I don't know if I have much to share with you except that, so we had fiscal year 24, what, was budgeted. And then in 25, there was a little bit, additional, appropriations that was provided. $300,000 was added, to justice reinvestment. And then we provided another like 3%. Yes. Do you have?
No, I'm
Oh.
just,
So there's a couple of components to this. So the first piece, is the money that's going out to the providers. And so that's what you're seeing right here, is by each provider. And then, if you go down a little bit on the bottom, I have sort of where some of the other funds, there's, some money for transitional housing. There's a general, fund and a global commitment. And then there's a little additional funds for the Vermont Network. And there's additional funds, that the, council identified for the Vermont Network as well.
so my look on my face
Yeah.
was the 900,000 is what we have carved out, and we've worked with Representative Squirrel, Trevor Squirrel, on this. 900,000 comes out of basically DOC's budget that would go towards our community partners for justice reinvestment.
That's right.
And that basically goes to the network and transitional housing. It does not go all the time. Sometimes there was a one-time thing that it went to our community justice centers, but that's not the normal path for the money. The money from justice reinvestment each year is about 900,000.
Yes.
And where those dollars go.
Yeah.
And what services we get and how effective that is in continuing our goal of keeping folks out of an incarcerated bed.
Yes. So from my understanding, the council provided a memo, and of the 900,000, maybe 500 or 600,000 was identified. And that's in this column here.
Which column?
Council, where it says the CJRC includes one-time funds.
So,
That's under council, right?
Yeah. Yes.
Martin?
yeah, I guess I don't entirely agree with what you just had said, Alice, because I'm looking at Act 40 S14, and from what I understand, it says when I'm looking at it, it's the funding. One of the things that this group looks at is the funding for utilization by individuals served through Justice Reinvestment 2 and related initiatives, including agencies, departments, municipalities, programs, and services employing restorative justice principles, including community justice centers. So I think community justice centers can be part of whatever funds are coming out of this.
So when we first started with justice reinvestment was based on bed savings in our out-of-state bed contracts. Okay, so the first year was pretty minimal, was like maybe 300 or 400,000. And then the second year, it bumped up to over $1 million that we had to figure out where we were gonna put it. And we divided that up between, I'm trying to remember, there was transitional housing, there was the network, and there was this one-time infusion to help our CJCs. And then we negotiated with DOC, it was Appropriations Committee, I think, Representative Dolan, Karen Dolan from your committee, and maybe a member or so from my committee. We figured out that on a yearly basis, there would be 900,000 coming out of DOC's budget for for justice reinvestment. Instead of looking at the out-of-state bed contract, we carved out that 900,000. And then that kind of all got lumped into, in the budget, the line item, we put in justice reinvestment line item in the state budget, but we also brought in previous monies that would go towards the community justice centers as well. So I guess I'm just thinking of that actual 900,000 because that was initially new money to what's already in the pipeline for justice centers and all the other initiatives.
Yeah, and I'm not saying that that's where the money goes, but it is one of the categories that can be considered from looking at Act 40.
And to provide context on that, because there was so much confusion when we were doing this 2 years ago about what justice reinvestment actually was, because some people talk about it in a broader sense than just those 4 subject areas of transitional housing, the network, and excuse me. And so what it was almost a redefinition of it. That's why CJCs and the providers themselves were sort of included in that initiative, because the council was established to take sort of more of a holistic view of sort of the restorative justice system in the state. Whereas the Council of State Governments kind of looked at it with these 4 areas. So they wanted to roll CJCs into sort of what a lot of people thought justice reinvestment was anyway. So hopefully it didn't further complicate it even more, but it just rolled in initiatives that were commonly talked about within the justice reinvestment realm, if that makes sense.
So the whole goal of all of this is how effective are these services and programs being in keeping people out of an incarcerated bed? That's the goal. Because we have a lot of initiatives going on that were already going on, and then we put in justice reinvestment 2 into those initiatives. And I'm specifically for justice reinvestment 2 is that 900,000 that gets added on to everything else that's already been happening.
Right, and if that $900,000 is sort of what the commissioner and the department agreed that they could go up to. But I think there was conventional wisdom that it really wasn't ever going to reach that $900,000. I think it was going to be somewhere around the 400 to 500 range. But ultimately, there's a recommend of up to that amount, but the commissioner can do whatever he wants.
Chair Emmons, may I speak?
Yeah, Trevor.
This continues to be confusing because when we did set this up a couple of years ago, 338.1, we pulled all the transitional housing, the current funding for CJCs into and added the 900,000, as you said, we negotiated with DOC when we worked away from the funding mechanism for out-of-state bed savings. In FY24, there was $899,000 to play with. And what happened is 108,000 was appropriated to DCF for the barge program. And so that continues to be encumbered. And the reason that was done is that we under the new 1115 waiver that was negotiated with CMS and AHS, but barge activities were able to draw down global commitment funds. So it ended up not turning that 109,000 into 250,000. So that was encumbered going into FY25. Also, the Senate took $300,000 of this money in FY24 and created base funding for the Vermont network. So that was an additional 300,000 that ended up being encumbered going into FY25. It was my suggestion to the various, both our committee, House Appropriations, and also in my discussion with Senator Sears and that side of the aisle, if you will, to move that out of that 900,000 and create the base funding for Vermont network. That did not happen. So when the council got the amount of money available to make recommendations on it, it was already down 400 and essentially for 409,000. So we had about 490,000 to make a recommendation for requests, and 131,000 went to reentry programming, and the 359,000 went to the community justice centers, which was added to 300,000, which actually made according to the community justice centers whole for FY25. But my sense is that while the 131 and the 359 is one-time funding, I just think this is going to need a whole nother set of discussion and conversation as we go into the next year and how we want to structure this, and whether we want to get back to sort of the ability to year utilize that $900,000 for, dare I say, special projects or maybe some new things that other states may be doing that we may want to take a look at. So I think a conversation for coordinated justice reform advisory council, but also for the committees of jurisdiction.
So it's really difficult to follow the money. That's what it comes down to. It's really difficult to follow the money, where it's going, what it's being used for, and is it having a positive impact in keeping people out of jail, which was the total goal. And we keep going round and round and round on this with justice reinvestment. In theory, you take your savings from not using that bed and you invest those dollars into programs in the community and provide wraparound services to folks. That's the theory.
I think your point is well taken, but a lot of the discussion over the past 2 years about this is the need to transition away from what was being done, to what Representative Squirrel just said. It requires a discussion with the advisory council and then a continuation of that during the next session. But, really, I think the council was envisioned to be sort of the starting point of, you have all the stakeholders in the same room and say, okay, this is the next phase and evolution of the system. And that could include funding of the system, and then maybe make a recommendation in their report come, September and then later November, or November rather. And then that could be the committees of jurisdiction could kind of take off and run with any recommendations with that. So it's going to be, I think, it's a slow and painful evolution, I think would be a good way to describe it.
Well, I think just to jump in as well, I think part of the problem is that some of these organizations and some of these functions like the CJCs, the network, have on an annual basis been underfunded, and we're looking to this fund to backfill that, and it's not workable long term. I think we need to continue to look at, funding those entities appropriately, and then using this fund for the purposes that Trevor just said, which is looking at one-time spending, one-time projects, and the like. But we're not there yet. So.
I think you're absolutely right, Martin, because I know with both the network and even the CJCs, this was this past session, where they had an infusion in the previous session, and they were expecting to get it again this time around when we were here in session. This last time, they expected to get the same amount. They didn't see it as one time. And we were seeing it as one time just to kind of give them that 1-year boost. And I think you're absolutely right. The issue is we're not fully funding them to begin with. And we're using justice reinvestment as a way to backfill.
Yeah, we're using Band-Aids on what I consider really important services that these entities are providing that in fact are keeping people out of prison as well. So
I don't know where to go from with this. I don't know.
should we put this definitely on our agenda for further discussion on how this Coordinated Justice Reform Advisory Council is working?
Who was on that council? I know that came up with your committee, Martin, and working in that.
No, I am.
You know who's on the council?
Yeah, Trevor is on the council. Or do you want to know the other people who are on it?
Myself and Senator Sears were on that, and then a collection of other stakeholders such as the CJCs, Vermont Network, Judiciary, Racial Equity Office. I'm probably missing a few folks in there, but we'll be meeting. We'll be meeting, and I can carry some of this discussion into that next meeting, and part of our reporting requirements or process, we can make some recommendations around that too. As I said before, I think it's something that's going to carry into the next legislative session.
Who's the leader?
I believe the chief judge is Judge Sony is the
Chair.
is the chair or whoever someone who designates. But I believe last report he was listed as the chair. And the members of the committee are the Attorney General or designee with experience in community and restorative justice, the chief judge, Commissioner of Corrections, Commissioner of DCF, the Executive Director of the Vermont Center for Crime Victim Services, the Executive Director of the Vermont Statistical Analysis Center, that's the crime research group, the Executive Director of Office of Racial Equity, and then Representatives Squirrel and formerly Senator Sears.
So Trevor, for us to get a better understanding of this, like what Martin was saying, well, maybe we ought to schedule some time to look at this further and understand it better. Would this be something that we would do more in September, October, November meetings so that we have a better understanding of where the council is headed for next session? Would it be better to wait till then?
It works for me. I mean, that's fine.
What do you think, Martin? I just don't want to have them come in just for the sake of coming in and then we don't know what we're going to be looking at.
No, I think that makes sense.
And they make their first recommend to the commissioner of their budget by September 1. So maybe after that initial recommendation.
September, October, something like that.
Yeah.
So Amy, I think that's where we're gonna head. So that's a good segue, I think, for us as a committee in terms of what are some of the thoughts that we want for future meetings, and also kind of the time frame. I'd like to get what days of the week do not work for people, so that when we send out a doodle poll, we won't include those days of the week for that. So what I have gotten down so far, just for today, is a review of the pretrial program. And we need to make a recommendation in terms of the $687,000, where that's gonna go. That needs to occur in August. And then we need an understanding of earned time, so that we can figure out, do we expand it to parolees? Do we expand it to like education credits if they're doing an educational program? Do they get additional earned time? Aisha brought up the issue, and she was sending us an email that Dick Sears had a concern that some of the sentences may be too long, based on what the crime they were convicted of, but she was gonna send that. She may have already sent it, I just haven't seen it.
So can I just ask a quick question on that to understand
Yeah.
that? Is it that the sentences that are being imposed, or the maximum sentence in statute?
I don't know. Keisha brought this up, and she was gonna send the email to us that she and Dick had. I think it was an email from Dick that she had.
Okay,
She was gonna find it, and then she was gonna send it.
so just on that issue, then, as folks may recall, last biennium, the House passed 3 bills to restructure the criminal code, and it dealt with sentence lengths to try to rationalize the length of sentences across different kinds of crimes. I guess Bob would have been in the House Judiciary at the time. And it didn't actually make it through the Senate. They just didn't get time. It timed out for them to look at those 3 bills. So that may be something worth considering in that context. Let's see what that email from Senator Sears is first. But I just flagged that there's been a significant amount of work that was done last biennium, and actually the biennium before that, we passed a bill out to start this process, and the Senate timed out on that one as well.
So I'm gonna depend on you, Malcolm, to kind of follow up on that, depending when we get the email from Keisha.
Yeah, sounds good.
We also wanted some updates on the women's facility. The new one, updates and direction on that.
That's really critical. That's at the top of my list.
So we could do something like that in August. Maybe.
Yep.
There's stuff happening in August. Yeah, August 1st. But we wouldn't meet until the end of August. Would that be?
I was thinking, Alice, we could put facilities together. We could talk about the women's prison, the juvenile facility, and where that is. And then, does it make sense to have a continuing conversation on transitional housing, or is that something that you think would come later?
That would be later.
Yeah, okay.
For facilities, would be the women's facility, the juvenile facility, and I would also include the secure residential,
Yep,
because there needs to be updates inside that
right,
building.
River Valley.
Yeah. That we can do next month, whenever we meet. And then, I know that there's concern about healthcare. There's concern about trying to look at the WellPath contract.
Yep,
And how all of this is connected with Medicaid, 1115 waiver, DEVA, the whole 9 yards.
well, it would be interesting to hear from DOC and Wellcraft, obviously, but it would be good to know exactly what our expenditures are for the contract, and then any other additional expenditures with, special services. Is there anything additional that we're seeing with hospital services or others? And then,
For
if we were-
DOC folks, right?
yes, and then remember when Annie Romanescu gave us an estimate of the total cost, how much
Yeah.
it would cost us if we were going to pay for a care outside of a contract, like having it administered through DIVA but not be Medicaid, that would be an interesting conversation. It's something my committee never got to, but at least we could begin a conversation between DIVA and DOC.
So you're saying if we provided, instead of contracting out with a private entity to provide our medical and mental health services, to do it in-house? We
Mhm.
talked about that last year.
Yes.
And just as DOC said, it would cost about 80 to 100 million.
That's right.
That's what they said. There were questions that we brought up, sometimes, I think Ginny was leading this, in terms of, if you reached out with our partners, be it DIVA, to provide some of these services, there could be other monies someplace else. It doesn't have to come out of DOC's budget to provide it. That's what you're getting at, right, Ginny?
Trying to sort that out, exactly. And that may not be something that we can do, but we might at least get to the questions that need to be asked in our regular committees.
So that's what I've got, yeah.
How about, as a consideration, defense attorneys or actual people, individuals that came out of incarceration? Find out from them how that transition took place.
In order to understand what you're saying, then what we should do is do an update on 876 in terms of what we put in for transition reentry. We should do that so that the committee understands what we put in place this past session for when folks are reentering.
You want to tie that with maybe the earn time intro, since it's all part of that bill?
Sure. But Tarbert wants to also hear from folks who have actually been incarcerated and transitioned out.
I want to find out from their point of view what happened. Because people can tell us all day, what we're doing this, we're doing that. Let's find out if that really happened.
I'm trying to think what's the best way to reach out, find those folks.
That's why I mentioned defense attorneys. You know, people that were defending them, maybe they, like for instance, when the judge says we would talk to the attorneys and figure out how to get that done. So they might know, was that a smooth transition or was it not? Is it any better than it was? Because from what I can understand, it's pretty poor. Or it was.
Potentially prisoners' rights within the Defender General's office.
Yeah, that might be a good start.
Yeah, I'm thinking, there's a fellow named John Elwell, I think.
Yeah, it's Wendy Harrison's son.
Okay, he was, I thought they testified once.
He did,
Yeah.
He did.
There's advocacy groups, that was Justice,
Yeah, okay.
for that. Let's see what we can find. It might not be next meeting, it'll probably be more in September. Yeah.
Well, you know, there's a couple of things that the recommendations due to the Department of Corrections,
Pretrial supervision.
pre-trial, that's coming up quick.
Pretrial supervision, that's next month. Yeah, we've got that.
Raise the age.
That's just a report to this committee, yeah, and that's at the end of July.
So-
So, yeah, we want to discuss it with.
Yeah, we can figure out agenda wise what's priority, but what are some of the other items that folks would be interested in? Anything besides what we just talked about?
Yeah, can I hit
Yeah.
on a couple? So there's a push by, not a push, an interest certainly by RDAP, which I'm not going to try to say their whole what their acronym stands for, but it's racial disparities in juvenile justice. So they're looking into something that the Office of Racial Equity has been working on and is using in the administration, and it's an equity assessment impact tool. And I do understand that RDAP may be pushing the legislature to be using this tool when considering legislation as part of our process. And it might be helpful to for us to understand that in the context of the legislation that we deal with in the area of criminal justice and corrections and such. I would suggest reaching out to probably the Office of Racial Equity, but also Professor Eitan Nezred and Longo of RDAP as a possibility for them to explain what they're pushing on that.
Actually drafted a bill last session that would have required those impact statements before any law was passed in the state, so I could.
Right. Yes, there's that kind of legislation, but there could also be something short of actually having a bill for that requirement, but we should understand. I think it's something that we're trying to pay more attention to as well in House Judiciary, but it may be worthwhile to hear from them. If nothing else, hearing from RDAP, which I know we did last year. We had them in for 10, 15 minutes to give us an update. I think that would be helpful. The other thing I had is, and I understand that we're going to be doing this anyway because we're going to be expecting the report at the end of July, but I didn't hear any talk about the raise the age reports. And I really want to keep the heat on the administration. If for no other reason than this was kind of could be a parting gift to the memory of Senator Sears, because this is something he has been pushing for the last number of years. And I do not want to see it extend past April of next year, which is the date that it gets started. And my shorter term goal in just keeping the heat on is to be set up to understand what DCF should be asking of the legislature when we come to the budget adjustment, and what kind of resources they're going to need to actually be ready in April for that further implementation of raise the age.
We should do that at our next meeting, possible.
Yeah, I would keep that on for every meeting that we've had every other month, at least, when we get an updated report each time. And I don't know if it's appropriate with that kind of interim goal of the Budget Adjustment Act, but I think that that's a good thing for us to keep our eyes on, because sometimes an administration will not provide the funds necessary to do what's necessary.
That's right. That's right. And that also ties in a little bit with the new construction of the juvenile facility. It ties in with that. You've got to get those beds up too.
Right.
Yeah, that was something the administration said was almost a prerequisite to raise the age, was getting the facility going.
Yeah, so that'll be good too, because if we do the update on the facilities in our August meeting, we can also have this, so we need this report, Jeff.
There's also the criminal ceiling stuff.
So Alice, I'm wondering if, just knowing where the negotiations are right now with the, for the citing the women's prison, and then also with the juvenile facility, I'm wondering if having it in September might provide for a more information and a more robust discussion. But I guess I leave it to all of us to think about that.
Well, that's going to lead into, let's figure out, we're entitled for 6 meetings. Do we want to try to have a meeting towards the end of August. I'm not thinking middle of August, I'm thinking towards the end of August. Or do we bump that to the 1st of September? I think by the end of August, beginning of September, we have a better idea about the women's facility, right?
Better than today.
Better than today, but there may be some meetings occurring between now and the middle of August that might help for clarity. Or not.
No decisions made,
Hmm?
but no decisions made.
No decision going to be made for a
We're not gonna
while.
be able to speak specifically about anything.
What are people thinking for when we should meet next time? So if we have one at the beginning of September, we have our second one, October, November, December, that gives us 5 meetings.
We can have 6, right?
We can have 6 meetings total.
Well, is this 6?
No,
This is 1?
yeah. So if you did in September, it'd be our second, September, October, November, December. So what are people thinking?
It's just hard because we're elections.
It's a long time for this.
I think, doesn't that give us 6?
This is our first meeting. If we do one at the beginning of September, October, November, December.
Well, we could do it the 21st or the 28th of August, but then,
Then you're kicking it down to the end of September.
yeah.
You're gonna wanna get all 6, whatever you're adding on to this.
Didn't we meet in
Do we
June?
know?
We do wanna get all 6.
And that would mean, if we don't meet at the end of August, what it means is we're gonna end up having 2 meetings sometime. Yeah. You know, it'll be sometime in November, but this is an election season, so things are gonna get crazy.
Only gonna get better.
I mean, you could do it after November 6th.
You may not who's around the table.
Yeah, right. No.
Look at,
well,
the 28th of August is pretty close to September. That might relieve some pressure.
We had it the 28th of August, then you'd have another one towards the end of September.
Yeah.
How does Wednesday, August 28th work for people?
Right now, it sounds good. Who knows?
Who knows? It's definitely right for
Well,
me.
if you-
I
if
think.
you put
I
it
know,
in
I'm
right-
thinking about Keisha.
That's right. In case you're in a different world.
Okay, as long as everybody knows that, I'll make it when I can.
And I'm August 28th works for me, certainly.
It does work?
Yes.
So let's plan for the 28th.
That gives enough time to maybe appoint an 8th member.
Yeah. And then we can anticipate something towards the end of September. And shoot, Teresa Wood just texted me and said, for some reason, today's meeting did not register on her calendar. I wondered where she was. I was like, where's Teresa? Because I knew she could make it. The issue is gonna be October may be a little dicey because it's so close to the election. But let's do August 28th, and then we'll go from there. We will, Megan, Ben, and I will work up an agenda. It would be nice to get some updates on the facilities, but we don't know if we're gonna be able to do something. And get some background information on earn time, get the background information on pretrial supervision, and the background information on the medical part.
Want me to do that, so.
Hmm?
Do you want me to? do
Yeah, you could do that. So are you available on the 28th?
that? I'm available on 28th.
Okay. You put the key, it's in check. Oh, Megan's available on the 28th.
So we're just gonna schedule them
Yeah, schedule the 28th,
August
August 28th.
period.
Yep.
Okay.
We're gonna meet, and then we're gonna work up on a schedule. Now, we got one more thing to do before we leave. We gotta figure out the leadership.
Okay, let me make a motion to get that over with.
Well, let
Oh,
me,
wait a minute.
I'm gonna update, because I checked the resolution, so on the voting part, Everybody who's remote, you can vote up to 3 times for any reason, so you're good. And that's per committee, so this won't count against any other committees that maybe you're on, and remotely voting on during the summer as well. But after discussion with both the House Clerk's office and the Senate Secretary's office, we all thought that the cleanest way that would be compliant with the statute, which demands that the chair rotates, is to leave the chair position vacant and have Representative Emmons operate as a chair, as acting chair in her position and vice chair, and then just elect a clerk, which is supposed to be elected anyway, to sort of be the fill-in. If for whatever reason Representative Emmons is unavailable for a meeting. Stay away from terms like interim, and things of that nature. So the legal minds, if you will, thought that that would be the cleanest solution.
So keep the chairmanship position, keep it open, vacant. Have me as vice chair in charge, and then we elect a clerk, and the clerk would be the person that would give backup to the vice chair.
That is my motion.
And who would be the clerk?
Jenny,
Jenny,
Does that
Okay.
work?
That works. That's good.
Isn't the motion we need is to have a motion to have Jenny Lyons be the clerk? I don't know
Yes.
yeah,
that.
that's really all we gotta do.
Necessary.
Yeah.
So it'd just be the Jenny Lyons would be the clerk.
Okay,
That would-
second,
We want to get out of here.
any discussion?
Yeah, any discussion, all those in favor, say aye.
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 Opposed? Okay, it does pass unanimously. We solved this. It took us all day to do it. Welcome aboard, Jenny.
All right. Don't expect any minutes from me.
We'll be in contact, Jenny, myself, Ben, and Megan will talk about the agenda.
Perfect.
first.
Good thinking.
Soon as we get that done, we'll ship it out. Anything else before we finish up?
Move to adjourn.
Thank you. Yeah, we're done. Second.